futhi umsolo wesithathu ke na-ke bese baphethe-ke lapho usibhamu se-9mm pistol lapho-ke athi umsolo wesihlanu ke yena-ke wahamba wangena-ke ngemuva elandelana nomsolo wesine-ke lapho-ke bathi uZungu yena-ke udaba futhi waphinda walukhuluma lapho-ke ngaphansi kwekhasi lesibili-ke lapho-ke kumugqa paragraph 5 kumugqa wokuqala kuze kufince kumugqa wesithathu-ke lapho-ke ukuthi lapho-ke mayelana nesikhathi sehora laka-9-ke lapho-ke ngalo lelo langa lelo-ke athi into awayiqapha-ke lapho-ke kuwukuthi umuzi Sibiya umafika futhi bese kuma-bracket bathi Sandiso Ntanzi-ke lapho-ke bathi futhi nonkani uSifiso Zungu Ntuli kade behamba belisana emuva besiya ngaphakathi kule gumbi yokulala-ke lapho-ke kade likhona-ke kulo muzi kade likhona-ke ngaphandle-ke lapho-ke futhi akaze asho ukuthi wona umsolo wesine kade akhona-ke ebasele emuva nomsolo wesihlanu-ke ukuze behamba bengena ngaphakathi kulela kamura lelo-ke bathi futhi waphinda ukukhuluma khona njalo-ke lapho-ke ku-page kukhasi lesi-2-ke lapho-ke kumugqa wesithupha kuze kufince kumugqa wesi-9-ke lapho-ke lathi uZungu enakho khona-ke njalo ngaphakathi kwaGwabeni-ke lapho-ke wabona lokhu wabona-ke umuzi enikeza uGwabeni i-38 special isibhamu-ke lapho-ke futhi unkani kade aphethe-ke nakhe i-9mm firearm-ke lapho-ke isibhamu-ke lapho-ke bathi khona njalo phinda ukukhuluma njalo ukuthi lapho uMthokoziseni Maphisa futhi noCarlos Mncubeke bahamba fika bahlala-ke lapho-ke besanemuva hlala phezu kombhedo-ke lapho-ke bathi khona-ke njalo lokhu khona-ke ukungahambisani phakathi kwenkulumo yakhe-ke kade yayikhuluma ngesikhathi lesibekalana phambi kwenkosi yenkantolo-ke uma kade ebuza imibuzo umshushisi-ke futhi phecelezi nodaba lwemibuzo-ke lapho-ke noma nenkulumo yakhe kade ayibhalile-ke ngaphansi kwestatement sakhe ukuthi khona-ke izinto kade zingahambisani phakathi kwalokhu kade akusho futhi nalokhu kade akushilo ngaphakathi kwestatement sakhe bese wabuya futhi wakhuluma khona njalo lapho-ke wacaphula phakathi kwenkulumo kade ibuzwa-ke lapho-ke umnumzana uRamsipili-ke lapho-ke phecelezi nodaba lolu lakwamnumzana-ke lapho-ke uZungu-ke lapho lofakazi bakhe-ke kade bungahambisani khona njalo-ke la wathi khona-ke umnumzana bese wacaphula khona-ke njalo-ke bathi umnumzana uRamsipili uyasho khona manje ukuthi-ke naye umsolo wesibili-ke kepha-ke lapho uzothi ashintshe futhi asho ukuthi umsolo wokuqala futhi noma umsolo wesibili-ke bathi uyasho khona njalo ukuthi yena akakaze ambone-ke uZungu noma akakaze amuzungu ngaphambili futhi beqala kumbona-ke enkantolo kwelanga endluleke lapho-ke bathi uZungu khona-ke nje lapho wathi yebo-ke lokho uma ngabe lokho kuqhamuka kumsolo wesithathu-ke nosine nosihlanu-ke ngakuvuma ngihambisana nawe-ke athi kepha-ke umsola la kundawo esiqhamuka kuyona-ke ekhaya noma la yena kwazalwa khona-ke lapho-ke bathi bambiza nje ukuthi uNtanzi-ke loyo-ke umuntu bese baqhubeka futhi inkulumo khona-ke yasho khona njalo-ke ukuthi uZungu waphendula phecelezi nodaba lwenkulumo kade ibuziwe lapho mayelana nomsolo wesine-ke lapho-ke ukuthi ngabe bekamazi noma kade angamazi yini-ke lapho-ke athi yena akakaze asho inkulumo eqondile ukuthi ngabe bekamazi noma kade angamazi-ke lapho-ke futhi yabuya futhi waqhubeka inkulumo yakhona-ke yakhuluma-ke lapho-ke bathi uZungu ngesikhathi kade abuzwa-ke imibuzo lapho-ke abameli phecelezi nodaba lenkulumo yakhe-ke ehlukile engafani wayibhala ngaphansi kwestatement sakhe-ke lokhu-ke bathi ngake wakwenza wacacabha ukuthi yena-ke lokhu-ke akubhalile-ke phansi-ke nokade kungahambisani futhi kade kuyinkulumo engahambisani engaphansi ko-paragraph 5-ke lapho-ke bathi yena-ke lapho kukhona-ke yena-ke bekazama ukusho khona-ke njalo-ke athi wenza-ke iphutha lapho-ke bekazama ukukhuluma umsolo wesine futhi umsolo wesihlanu-ke ukuthi ibona-ke abangena ngaphakathi kwelela gumbi lakamnumzana kuGwabeni-ke kade kungasiyena-ke umsolo wesithathu-ke lapho-ke bese wabuya futhi umnumzana uRamsipili wambuza futhi-ke imibuzo-ke ngesikhathi lana-ke emphenya-ke embuza-ke imibuzo-ke lapho-ke mayelana nodaba lwakhe alikhulumile-ke ngaphansi kodaba noma lwenkulumo yakhe oyekade eyibhalile phansi lapho-ke statement sakhe-ke ukuthi bona-ke bahamba bayahake lapho-ke kwindawo esakhe utshwala usho ukuthi lapho-ke Tops Spa lapho-ke ngesikhathi bekahamba ephelekezwa-ke uSimameke uZungu-ke bathi ngiyacabanga waphendula ngokuthi-ke yebo ngiyacabanga ukuthi mhlawumbe-ke le ndlela abayisho ngayo-ke kepha yena akakaze wathi ngesikhathi bekahamba-ke lapho-ke awahamba-ke nabesilisa-ke futhi nangesikhathi bekabuya-ke wathola sekukhona-ke owesimameke futhi owesimameke-ke uyena-ke wamceda amthengele-ke lapho-ke utshwala-ke besathi yena-ke wahamba-ke wathenga-ke utshwala-ke lapho-ke bathi futhi inkulumo kaZungu kwayikhuluma futhi uma sebeqhathanisa phakathi kwenkulumo yakhe futhi bengahambisani-ke lapho-ke wakhuluma ngaphansi kwesifungo-ke langaphambi kwenkosi yenkantolo-ke kuwukuthi uZungu yena-ke wakhuluma mayelana phecelezi nomuntu bagqoke-ke lapho-ke ngela i-cap-ke kuyena-ke ukuthi umsolo wesibili-ke loyo-ke futhi wathi yena-ke umuntu ukhulume naye futhi ngesikhathi sekubeka lapho-ke ushuthi bathi umsola wesine-ke uma seyabuye eshintshe inkulumo yakhe-ke lapho-ke bathi futhi uZungu khona-ke inkulumo ayikhuluma-ke ngaphambi kwephoyisa-ke elikhulu-ke lapho-ke bathi uMajor General Lishabaneke okuwukuthi wamtshela ukuthi yena-ke akunalutho-ke alaziyo futhi ushuthi umnumzana uGeneral Shabana-ke wamtshela ukuthi yena-ke lapho-ke uzohamba-ke enzeke ukusesha kwecala leli-ke lapho-ke bese ngemuva kwalokho abuye aze-ke yena-ke lapho-ke amtshele-ke bese yena-ke watshela-ke uGeneral Shabana ukuthi yena-ke akunalutho-ke ayaziyo futhi kade akekho-ke ehostele-ke lapho-ke futhi washo ukuthi izathu lezo ukuthi kungani-ke wakhuluma lokhu-ke kepha kwabuya futhi washintsha-ke inkulumo yakhe lapho-ke uZungu-ke bathi khona kuZungu usho ukuthi ukhulumile ngocecebha ukuthi yena-ke uZungu-ke lokhu-ke kwenzeka ekuthizeni-ke acekele abasolwa phansi-ke bonkana lapho-ke ngesikhathi khuluma inkulumo yakhe lebengahambisani-ke bathi futhi uZungu wathi letha ufakazi bakhe-ke ngelanga lange-13 zakaNovemba ngomnyaka 2019-ke lapho-ke ngesikhathi bade nomhlangano lapho-ke nobaba uBrigadier Gininda-ke lapho-ke futhi bathi wabuzwa-ke nakho ukuthi mhlawumbe yini ayaziyo ngokushona noma ngokubulawa kaSenzo Meyiwa-ke lapho-ke bathi nakwaqhubeka khona njalo washo njalo-ke uZungu ukuthi yena-ke akunalutho olaziyo mayelana nokushona kwalo muntu mhlawumbe nenkulumo lezi-ke bese watshela ukuthi ubaba uBrigadier Gininda-ke lapho-ke okuwukuthi yena-ke akunalutho futhi ayaziyo futhi akunalutho-ke athize wayenza-ke lapho-ke noma wazoyenza-ke lapho-ke bathi inkulumo uZungu wayekhuluma-ke lapho-ke futhi uma siyabuka futhi lapho-ke sebeqhubeka nenkulumo kaZungu-ke basho uZungu ukhulumile phecelezi nodaba lokuthi kufakazi bakhe-ke khona-ke umuntu wesibili-ke lapho-ke kade agqokile lapho-ke i-cap-ke yena-ke futhi nakule thombe lezo-ke kade akhona-ke futhi ngekhe asho khona njalo ukuthi kade kumsolo wesine noma kade ungasiyona umsolo wesine.
My Lord, by corroboration, I meant corroboration which implicate the accused in the commission of the offense. And there was nothing, absolutely nothing in the evidence of Zungu that implicate the accused in the commission of the offense. In fact, what Zungu testified about, he referred to not less than 5 people that he met on that day. Not people he met on that day. He referred to not less than 5 people in his evidence. And such people were not called as witnesses in this case. And on the transcribed record of the 7th of September 2023, on page 29, line 10 to 14, this is what the court said about such tendency of this witness Zungu to refer to hearsay evidence. And I quote, by court, just to place it on record that I will not entertain the hearsay, I'm not going to take it into consideration. Mr. Baloyi, as the court pleases, by court, all the hearsay, Mr. Baloyi, as the court pleases. So, the bulk of the evidence of Zungu refers to hearsay evidence in the sense that no witnesses were called before this court, despite him referring to those people were called before this court to corroborate the evidence of Zungu. The other issue, my Lord, that I wish to address is the concerns which were raised by court that at some point, accused number 2, Bongani Ntanzi, met Jack Telezi. That is after the court appearance of Mr. Ntanzi, accused number 2, before this court. He refers to this is what Buthelezi says upon that meeting that transpired. He says Bongani Ntanzi said there was a party and that he said he was in the company of his friends. He said it was Mapisa and them when he referred to his friends. By Mapisa, it was never pursued through the evidence in chief to this witness by the state, my Lord, to clarify to the witness which Mapisa was he referring to when he testified with reference to Mapisa that Mr. Ntanzi, accused number 2, had said he was with Mapisa at a certain party with his friends in Fosloras. Zungu could not explain what occasion on page 47, 48 of Exhibit C, despite claiming that he was with accused number 3 and 4. In his evidence in chief, he testified the person wearing a cap was accused number 2, but when confronted that the person wearing a cap was in fact accused number 4, Mr. Mapisa, he retracted his earlier version and said he could not see accused number 4 on the picture. The common purpose doctrine. Instead versus Mawala unreported case number AR267 of 2016, delivered on the 12th of October 2018, Pillage A at paragraph 19 said the following regarding the doctrine of common purpose. The court held that common purpose is a legal construct to assist the state in prosecution where evidence is insufficient to link offenders to one another and to the crime. It is evident that the principle of common purpose is not just a tool, but an effective mechanism created to serve justice. Without it, the state will have been clueless as to the true identity of the one who committed the act. The common purpose principle makes it easier to not just punish the true actor, but also to his co-conspirators who had the intention to commit such crimes that caused the unlawful results. Close quotation. Instead, versus Mketezi, 1989, Volume 1, Essay 687, capital letter A in bracket at 705 I to 706C, the court established that a person to be held liable for a crime committed under the doctrine of common purpose, where there is no evidence of prior agreement, the following criteria must be met. A, presence at the scene. The accused must have been present at the scene of the crime where the violence was being committed. B, awareness of the attack. The accused must have been aware that the criminal attack was taking place. C, intention to make common cause. The accused must have intended to make common cause with the other participants or other co-conspirators committing the assault. D, active association with the attack. The accused must have manifested his sharing of a common purpose by himself, performing some acts of association with the conduct of the others. E, intention to kill the deceased or to contribute to his death. The accused must have had intention to kill the deceased or contribute to his death. In the light of the facts of this case, it is important to note that the common purpose doctrine, as exposed in State versus Mgedes and others, has been pronounced by the Constitutional Court to be constitutional. In State versus Tebas, the most critical requirement of active association is to keep too much a liability. Current jurisprudence premise on a proper application of State versus Mgedes and others makes it clear that 1, there must be a close proximity, in fact, between the conduct considered to be active association and the result. Roman figure 2, such active association must be significant and not limited participation removed from the actual execution of the crime. Zungu's evidence, which I submit, that is version and that of accused number 4, are mutually destructive. Zungu met accused 4 at a hostel. Gwabeni introduced the accused to Zungu, despite Zungu knowing the accused. Zungu later met accused 4 after accused 1, 2, and 3 had entered Gwabeni's room. Accused 5 entered the room, followed by accused number 4. This is according to Zungu. After some time, he was going to his vehicle. He noticed that the vehicle keys were not with him. He went back and asked Gwabeni, where are the vehicle keys? And Gwabeni made a call to a person whom he thought was related to accused number 4. And he made a call to a person whom he referred as Mzala. And he thought that person was accused 5, did not answer the call. Zungu testified that accused 4 arrived and gave him the vehicle keys. According to Zungu, accused 4 showed his greatest fullness and clapped his hands together. Zungu's evidence, it must be noted, my lord, that it does not detail a plan by the accused to execute the assassination of the deceased. It does not place the accused together or even himself, Zungu, that he overheard such a plan. Zungu's evidence does not reveal any prior agreement amongst the accused, including accused number 4, to kill the deceased. In the absence of a prior agreement to kill the deceased, it therefore becomes important to apply the 5 principles as stated in Getty's decision. The presence at the scene. The accused must have been present at the scene of the crime where the violence was committed. There is absolutely no evidence, my lord, that accused number 4 was present at the scene of crime where the violence was being perpetrated, either circumstantial or direct, at or near the scene of crime at house number 135. My lord?
What about the confessions?
I'm still coming to confessions, my lord.
Oh, I see.
Yes.
Okay.
B.
That's amusing.
The issue of confessions, my lord.
And I'm not thinking what you're thinking.
No, I'm absolutely, you're in different terrains.
Yeah, I can tell you what I'm thinking, not what you think I'm thinking.
All right, thank you.
Section 218
218.
and 217. What do they say?
217 is admissibility of a confession.
217 is about pointing out.
218 is pointing out.
Okay, fine. And then 217 is?
Admissibility of a confession.
Yeah, fine. What does it say?
I'll have to get.
Do you have the F there so that we all educate ourselves?
In fact, 219 is, I think, for the purposes.
219 is no problem with 219. Yeah, let's read it.
217 is quite lengthy.
Yeah, quite, yeah.
Yeah. Well, must I
Yeah,
place on
yeah.
record the whole of it? If it carries my land firm's blessing, Section 217 reads as follows. Admissibility of confession by accused. Subsection 217(1). Evidence of any confession made by any person in relation to the commission of any offense shall, if such confession is proved to have been made freely and voluntarily by such person in his sound and sober senses and without having been unduly influenced thereto, be admissible in evidence against such person at criminal proceedings relating to such offense, provided, paragraph A, that a confession made to a peace officer
Just bring that thing here. It's not what I want us to read. You know what I want you to read?
No, I'm not thinking what you're thinking.
Yeah. Yeah.
Perhaps they could have in mind the confession made to a magistrate, that is prima facie.
Yeah. All right. See. Yeah, just listen. Here it is. It's admissibility of facts discovered by means of inadmissible confession. It's section 218, subsection 1.
Yes.
You know.
Yes.
Evidence may be admitted at criminal proceedings of any fact otherwise in evidence, notwithstanding that the witness who gives evidence of such fact discovered such fact or obtained knowledge of such fact only in consequence of information given by an accused appearing at such proceedings in any confession or statement which by law is not admissible in evidence against such accused at such proceedings, and notwithstanding that the fact was discovered or came to the knowledge of such witness against the wish or will of such accused.
I'm still trying to understand the...
Okay, you remember Ginanda?
Yes.
Ginanda, you kept on asking him, how does he know that accused number 1 is involved? How does he know that accused number 2 is involved, etc., etc.?
Yes.
And Ginanda said, as the investigating officer, after accused number 1 allegedly made a confession to Maboto, I went to fetch the confession the following day, and I read it. You remember?
Yes, I remember that.
The same thing he says about accused number 2, I think. Rapadi, after Rapadi had made the confession,
Yes.
written the confession,
Yes.
this guy repeats to say he went to fetch it and read it.
And read it, yes.
The same thing with the magistrate Kronje. After he gave the confession to Mrs. Kruger, the senior,
He did the very same
he
process.
did the same thing. So in
Yes.
other words, if you read this, you'll get what is meant by this. So he acquires that knowledge, Kininda, by the fact that he read the confessions. And that evidence, according to this section, is admissible to him. But it is not as admissible as against a co-accused.
Yes.
Fine, you've helped me now. What do you think, Mr. Baloy? Is it witchcraft?
Yes, in fact, we question the case of Korashi, I think, that deals precisely with that one.
Okay, fine. Let's go ahead.
B. Awareness of the attack, the accused must have been aware of the criminal attack was taking place. There is no evidence that accused 4 was aware that the criminal attack was taking place.
Okay.
C. Intention to make common cause. The accused must have intended to make common cause with the other participants or those committing the assault. There is no evidence that accused 4 intended to make common cause with those committing the assault. D. Active association with the attack. The accused must have manifested his sharing of a common purpose by himself performing some acts of association with the conduct of others. There is no evidence that accused 4 manifested his sharing of a common purpose by himself performing some acts of association with the conduct of others.
Okay.
E. Intention to kill the deceased or to contribute to his death. The accused must have had intention to kill the deceased or contribute to his death. There is no evidence that accused 4 had intention to kill the deceased or to contribute to his death.
Kanisa phakathi kwicala lezombuso ke futhi noMalawa elingarapotiwe lapha ekheha icase number khona wathi AR2 elakade isinqumo sakhona sethulwa ke ngelanga la nge-12 zaka-October ngo-2018 inkosi inkantolo uphile ke lapho ke athi ngaphansi ko-paragraph 19 ke lapho uma eqaphula khona ke lapho ke bathi inkantolo khona ke yasho khona kumalana nokwenza into ukuthi lapho nihlele phansi ke niyiqembuke lapho ke athi malana nodaba lozomthetho ke lapho uma sekusenziwa lokhu ke lapho ke kathi kwamele ukuthi kubheke lokhu kulandelayo futhi ngendlela elandela ukuthi ngabe mhlambe abasola lapho ke baqhumana kanjani bonkana kuphecelezi nalo daba noma licala lelo ke noma nofakazi ade bukhona ke lapho ukuthi mhlawumbe ke ngabe ade buhamba kanjani futhi busho kanjani ekuthizeni ke lokhu abasola bakwenza nabonkana behlangene futhi behlele ihlelo elilodwa ukuthi benze lokhu ke lapho ke wabe futhi eqhubeka phecelezi lenike icala lapho ke lombuso futhi libhekene lapho lomgedezi icala la ngo1989 lapho ke volume 1 SA 687 ke lapho ke la bafunda khona ke phecelezi namaphuzu amahlanu ke lapho ke uma ngaba bekhona phecelezi ngodaba lokuhlela ke icala ningabantu abaningi ke lapho ke noma niqembu nehlele into ethizeni mhlawumbe nenze ke lapho lapho lomthetho mhlawumbe ubugebengu obuthizeni ke lapho ke athi kwamele ukuthi iphuzu lokuqala ke lapho ke abakhuluma ngalo ke lapho ke kucala likamgedezi ukuthi lapho ke abantu kumele ukuthi babe khona ke ngaphansi kwendaba yesigameko lapho ke noma babe khona ngaphansi kwendaba yesigameko bese benze lokhu ke lobugebengu ke lapho ke kade bebenza noma mhlawumbe kade behlele ukuthi babenzeke lapho ke bese iphuzu lesibili ke lapho ke ukuthi wazi ukuthi ngebo empeleni niyahamba niyohlasela ke lapho ke wathi khona ke lapho kumsolwa naye kwamele ukuthi abe nalo kulwazi lokhu ukuthi lapho bayahamba bokwenza kobugebengu lapho ke abathi iphuzu lesithathu ukuthi abe nenhloso futhi enze lokho ngokuyimisela ekuthizeni naye adlale ke isikhangiso kulobugebengu ke lapho ke bathi futhi iphuzu lesihlanu ukuthi nake futhi abe khona ngaphakathi kulophuzu lesine ke lapho ke ukuthi naye abe khona ke futhi ngaphakathi ekwenzeni kobugebengu ke lapho ke futhi iphuzu lesihlanu ukuthi lapho ke naye futhi abe nenjongo yokuthi izini ke naye abe nesandla ekuthizeni babulale noma ke busola naye basho khona ukuthi umsola lapho ke lokho yena ke kumele abe nalo ulwazi lwakho ukuthi yebo lapho kade behamba bekwenza lokho ke athi mina phecelezi udaba lolu becaphula phakathi icala lombuso ubhekene necala likamgedezi ke lapho ke kade bekhuluma ngalo ngaphansi kwe constitutional court lapho ke yana ke eNingizimu Afrika ke ngesikhathi becaphula lapho kummeli wenu ke futhi eqhubeka washo khona njalo phecelezi nodaba lwenkulumo ekade lethiwe lapho ke uzungu ke ukuthi uzungu yena ke into ayikhuluma noma inkulumo eqhamuka kuyena ke ukuthi lapho komsola wesine ke lapho ke kade angamazi futhi uzungu yena akakazi ukuthi futhi uzungu wahlangana nabo ke lapho ke hostel egwabeni ke lapho ke futhi kwaba ugwabeni owazisa ke abantu laba ke kuyena ke uzungu ke ukuthi naba ke abantu abathizini ke lapho ke wathi uzungu ngemuva kwesikhathi ke lapho kwahlangana futhi umsola wesine futhi umsola wesibili uqala nowesibili nosithathu ke lapho ke ngesikhathi ebengena ngaphakathi lapho kumuzi kwagwabeni ke lapho ke bese ke nomsola wesihlanu wahamba wongena ngaphakathi kwala music ngesikhathi umsola wesihlanu ngelapho engena ngaphakathi ke lapho ke kade asalwe emuva komsola wesine ke lapho ke bathi futhi uzungu khona ke la inkulumo yakhe bengahambisani khona ke futhi beyakhuluma futhi abuye ayilungise phecelezi nenkulumo yakhe ke lapho ke bathi kwesinye isikhathi uzungu washo khona njalo ke lapho ke ukuthi bekayimisela ukuhamba ngemoto yakhe kepha ke ngesikhathi bekazimisela ukuhamba ngemoto yakhe ke athi la uqapha khona ukuthi ukhiya wemoto kade ungekho ke kena bese washayela ke bese ugwabeni ke washayela ke umuntu uthizini ke ekhuluma naye ucingweni phecelezi nodaba lwezikhiya lezi moto ke lapho ke bathi uzungu nawacaba ukuthi mhlawumbe umsola wesine ke lo ugwabeni beyakhuluma naye ucingweni phecelezi nodaba lolke lwekhiya lembuza moto ke kepha umuntu kade bembiza ngegama noma igama lakhe kade bembiza njengokuthi umuntu kade kumzala ke lapho ke bese nokucabanga ukuthi mhlawumbe bikade kumsola ke wesihlanu ke loyo ke bekashayela ucingo kepha akaza liphendule ke ucingo lwakhe ke lo muntu loyo ke wabuya futhi uzungu wakhuluma phecelezi nodaba lwenkulumo yakhe ke lapho ke noma phecelezi nodaba lwekhiya lapho ke la wathi khona ufakazi bakhe ukuthi lapho ke ngesikhathi kade kusenzeka lokho ke lapho kuzungu uzungu wakhuluma ufakazi bakhe ukuthi lapho umsola wesine ke wafika ke lapho ke ngemuva ukuthi afike kwese wamnika lapho ikhiya zakhe zemoto futhi ke ngesikhathi eqeda umpaka ukhiya bemoto ke lapho ke athena bekajabulile futhi bekasebenzisana nje kahle futhi wamshala ke izandla lapho ke washo khona njalo uzungu ngesikhathi ufakazi bakhe lapho ke ekhuluma phecelezi nodaba loluko elohlelo lakhe ukuthi na ke lapho ke lokhu ebonaka akakazwe abezwe ke bekhuluma phecelezi nokuhlelo nalo hlelo lwabo ke noma bezwe mhlambe noma ababone bevele bekhulumisana beqeda bobonkana abasola lapho ukuthi bezohamba webulala ke lapho ke umufi ke wabuya futhi ummeli washo khona njalo ukuthi malana nodaba lolu ke lapho ke phecelezi nodaba lecala leli lamgedezi ke athi uma ngabe ke abantu behamba bebulala kumele ukuthi sibe khona ke sivumelwano lapho bazothi bavumela khona ke ngento eyodwana ke futhi khona ke amaphuzu amahlanu ke lapho ke aphule khona ke lapho ke ummeli iphuzu oqala ukuthi lapho ke kumele ukuthi umuntu ke abe khona ngaphakathi kwindawo yesigameko lapho ke bathi khona ke njalo ke kepha kumsola wesine nakade angekho ke lapho ke ngaphansi kwale ndawo yesigameko ngesikhathi kade kusenzeka lobugebengu ke lapho ke bathi futhi kumele ukuthi umuntu abe nolwazi lokuthi yebo siyahamba siyohlasela ke lapho nonke ehanjwe kuyohlaselwa ke lapho ke bathi khona ke njalo umsola ngamunye ke lapho ke kwamele ukuthi azi ukuthi udlala isikhangiso siphi uma ngabe senza uma kusenziwa ke lolu hlelo ke lapho ke bathi kepha kabukho ubufakazi obusho khona njalo ukuthi umsola wesine ke lapho ke yena kade analo ke ulwazi lokuthi bahamba bokwenza lokho ke kule ndawo kade isenzeka kuyona ke lobugebengu ke lapho ke bathi futhi umuntu yena enze futhi ngenjongo noma mhlawumbe yebo enze ngento ejwayele ngendlela futhi ekhethekile ethizena ke kade isikhangiso ke lapho ke bathi khona njalo kabukho ubufakazi obusho khona njalo futhi lapho umsola wesine ke nakhe kade khona ke lapho ke futhi naye wahambisana nabanye ke bonkana benza njengethimba noma njengeqembu ke lapho ngesikhathi kade bekwenza ke ubugebengu lobo ke bathi futhi kwamanje lapho wasebenzisana nabo ke abanye futhi oza kwabo ke uma ngabe sebesenza lo bugebengu lobo ke bathi futhi lapho kuyasho khona nje umsolo wesine ke lapho ke akukho la kusho khona ukuthi nake kade khona ke lapho ke futhi noma kade analo ke ulwazi bese futhi bele ukuthi abulale ngenhloso ke lapho ke bathi khona ke njalo futhi uma ngabe sebesenza lokho ke umuntu abulale njengenhloso ke njengabanye ke lapho ke abasolwa ke ekuthizini bafezekise lokuzana ithimba labo ke noma mhlambi ukuhlela kwawo ke kuzinto njengethimba ke lapho ke bathi khona njalo umsolo wesibili ke lapho ke nake akanalo ulwazi futhi akazenze lokho ke ngenhloso ekuthizini ke abe nesandla ekuthizini ke umufi ashona.
The effect of failure to call available witnesses. The failure of a party to call a witness could, under certain circumstances, justify an adverse inference against that party. It is generally true that where a party fails to lead evidence, available evidence, which can clarify the facts before court, such failure leads to the inference that it is feared that such evidence will expose the facts unfavorable to that party. In this regard, my Lord, Ms. Kelly Nxumalo was not called to testify despite being the complainant on the third count of the indictment. An adverse inference will be drawn in circumstances where the state failed to call another witness or witnesses as corroboration, where such witness or witnesses were available to give evidence and was in a position to clarify facts relevant to the case. Evidence of identity. Evidence tendering to prove the person's identity may be direct or circumstantial evidence. Direct evidence is the testimony of the witnesses who says, for example, that the accused is the person whom he saw emerging from the shop at midnight. I submit that there is no witness or witnesses that place accused number 4 at or near the scene of crime. The witnesses who testified viva voce before this court did not implicate accused number 4 as one of the intruders, or that at some point they, that is the intruders, after they had fled, another intruder entered the house. The assertion by Brigadier Kininda that accused number 4 entered the house must be rejected as false beyond reasonable doubt, as they do not find support from the witnesses. Towards the Sitwala who ran out of the house after shots were fired did not mention this, nor it was raised by the state in examination in chief or when the state was leading this witness. No, the witnesses, Ms. Makete and Mr. Ngache, observe another intruder after the two intruders had fled the scene, coming out of the premises. Despite Brigadier Kininda, my Lord, reading the confessions, it is clear that he did not do any investigations in order to corroborate and find evidence alluende to the commission of the offense. I'm basing this because if it is true that accused number 4 entered the house after the two intruders had left, this was supposed to be investigated, and no investigation emanated from this point. the DNA evidence and fingerprints. Captain Mamshedi Phineas Masetla testified that he was the senior forensic analyst and in the service of the state. He undergone training when he joined the Forensic Science Laboratory in 2002 with reference to opening of parcels containing biological evidential material, the preliminary testing of body fluids thereof, and DNA techniques which he had offered knowledge and skills for forensic biological analysis. He testified that he received continuous training with the Forensic Science Laboratory up until 2006. He had approximately 25 years experience in the biological sciences. He was responsible for analyzing the DNA results in terms of doing the interpretation of the DNA results. He will then do what they call DNA comparison, where he will then have a case like this one, where he will have the DNA from the exhibit, from the scene, and they will also have the DNA results from the reference sample. The reference sample are the samples that are taken from the suspect or accused individuals. Captain Masetla further testified that he compiled what he got from those particular exhibits when conducting his investigations. The lab number allocated for the exhibits from the scene is lab number 217731 of 2014, and lab number for reference sample is lab 126265 of 2016, phosphorus case 636 of 2014. The exhibit and reference samples were contained in exhibit X11 of the record. On the 9th of October 2023, the records depict the following at page 75, line 2 to 4. Captain Masetla. At number 22, which details the description of suspect Mthokozeni Mapisa accused for, was excluded from all the samples. Close quotation. A report compiled by Captain Masetla, exhibit X12 in brackets, contains a table where the relevant results from the exhibit from the scene and reference samples are compared. The first sample is written sample with an indication of 1, that is swap 1, which has the container number 14DCAH8988 and contained in back number PA 400 2150107, which was taken from the door handle of bedroom 1. The next exhibit is a head, which is exhibit B, on the head DNA, and is analyzed with presumable high friction area. In simple terms, it is a sweat. A head was in evidence sealed bag number PA 3000 788535. Captain Masetla received the first reference sample for MZ Mapisa in container number 19DBA F0198 in seal bag number PA 400 4638062. The second sample that he received was from Mthokozeni Mapisa in container number 13DBAD 5906 in seal bag number PA 500 217 6171. On the 9th of October 2023 at page 77, line 1 to 6, Captain Masetla said the following. When you go to the next column, it is written gender marker or Emala Godin, which tells us the donor of that particular sample, if the donor is a male. If is a male, it will be XY, and if it is a female, it will be XX. In the context of a gender marker, if you have XY, it means that particular mixture, it can be a mixture between a male and a male individual, or simply terms, it can be a mixture of both or more than one male individual. So, and as well as if you still have that XY, it can be a mixture of a male and a female individual. So when you look at XY on a mixture DNA, you must always remember that XY, it does not mean that that mixture is an only male individual mixture. So in a mixture, that XY represents XS, which is a female, or XY, that is from a male individual. He testified that on the 10th of October 2023, page 2, line 13 to 24. My Lord, it is important that before I start checking whether I find that DNA in the swab or in the head, is that for us to say a person is included, you must have to include the person in all DNA regions. So reading a person in one single region does not mean that that person is included in the mixture. Mr. Prosecutor. Now, what is the position if you read that person in more than one region, Captain Masadla? If you read him in more than one region, you must not, for you to conclude that that person is a contributor of that mixture, we have to read him in all the DNA regions. There was a question by Mr. Malloy to the following. Are there any of these regions or loci that are more important than the others? In other words, that are more distinguishing? Captain Masetla asked that the following. We, in terms of distinguishing the character of the loci, we use them in combination to give us a distinguishing factor. So we combine them. It is not necessary to say we attach more importance to one than the other. We match importance to the combination of them all together. From what follows from the evidence of Captain Masetla, my Lord, was the analysis and comparison of swab 1, assembly head B, and various reference samples of known individuals, including Nxumalo Mapisa, accused number 4, and he came to the following conclusion. The donor of the following reference sample were excluded as the donor of the DNA on the swab 1, 14DCA H8988, and the head B presumable high friction area PA 3000 788-535, Phosphorus case 636 of 10/2014. The importance of this report or results, my Lord, is that circumstantially it further excluded my client, accused number 4, in the commission of the offense. The sole purpose for the head to be sent to this forensic science laboratory was in relation to the friction area, whether one look at whether the head has a sweat, not as what Brigadier Kininda wanted this court to believe. He did his own analysis, which do not find support from the report by Captain Masetla before court. Brigadier Kininda merely says that because the accused, that is accused number 4, is read in one of the regions, then one can conclude that such a report is positive. That does not find support, my Lord, from the evidence of Captain Masetla. And Brigadier Kininda further testified that because the accused is read in one of the regions, it is possible that he had touched the head. That was not the sole purpose for this had the exhibit to be forwarded to the Forensic Science Laboratory for examination. The evidence of Sergeant Vusumuzi Mohane. Sergeant Vusumuzi Mohane testified that he is employed by South African Police Service attached to the National Court Cases Unit. He testified that on the 20th of June 2020 at about 2100 hours in the evening, he was in the company of his colleague, the late Sergeant Mabena, when he arrested Bongani Ntanzi, accused number 2, at Bokeng in Rustenburg. On the 19th of June, accused 2 appeared before Lieutenant Colonel Rapado for a confession at Moroga Police Station. Accused 2's confession statement was admitted as Exhibit HH of the record. On the 24th of June 2020, the accused appeared before a magistrate, Ms. Cronje, for a second confession statement, Exhibit JJ of the record. On the 6th of October 2020, acting on the information that accused 2 had provided in his confession statement, Brigadier Gininda arrested accused number 4. Brigadier Gininda considered in his evidence in chief that he arrested the accused, that is accused number 4, based on information provided to him, that is Brigadier Gininda, by accused number 2 in his confession statement, that he, Brigadier Gininda, had no evidence against the accused, that is accused 4, before the confessions were obtained. Confessions not admissible against another in terms of Section 219 of the Criminal Procedure Act 51 of 1977. Section 219 of the Act provides that no confession made by any person shall be admissible as evidence against another person. In the Constitutional Court decision of Mhlongo and Nkosi versus the state, which was penned by Judge Theron, or Justice Theron, the crucial issue, my lord, was the admissibility of extrajudicial statements of accused against a co-accused in a criminal trial. The issues arose in 2 applications in which the applicants seek leave to appeal against their conviction and sentences. The court, that is the Constitutional Court, was called upon to determine the constitutionality or constitutional validity of the admissibility of these statements. At paragraph 18 of the judgment, the Constitutional Court justices find the history of the common law prohibition on extracurricular statements against co-accused. At paragraph 18, I quote the following. At common law, the extracurricular statement of an accused was inadmissible against a co-accused. This common law prohibition stemmed from English common law. In 1832, the Court for Crown Cases Reserved in R. versus Turner was called upon to pronounce on a conviction for theft. The conviction was based on the evidence tendered in a confession of a co-accused who was an employee of the complainant. The court unanimously held that the confession of an accused was inadmissible against a co-accused, and the conviction was thus wrongfully made. Close quotation. A confession of one accused may not even be used indirectly against the co-accused. What is meant appears from the judgment of State versus Batman, 1960, Volume 3, SA 535, capital letter A in bracket. In which case the 3 accused were convicted of murder. One of them made a confession implicating the other 2. All that connected the confessor to the murder was his confession, and all that lined the other 2 was that the three were in each other's company on or at about the crime of the offense. Although the indirect implication of the other two in the confession was therefore correctly left out of the court's considerations, neither JA found on appeal that they were nevertheless indirectly and wrongfully connected to the murder thereby. The decision based on Wigmore paragraph 1076, an English decision in R versus Turner 168 ER 1298, and the appellate division decision in R versus Nkosi and Zulu 1950 volume 1, parentheses all, H 91 capital letter A in brackets. Batman's case was followed by the appellate division in State versus Sorobe 1968 volume 4 SA 420A at 425G. A confession may not feature at any point in the chain of inference. Even indirect use of the confession for purposes of corroboration is not permitted. In this regard, see State versus Makeba and another 2003 volume 2 SACR 128 SCA at 133 paragraph 14. It follows therefore that no reliance should be on accused number 2's confession as corroboration of Zungu's evidence, either directly or indirectly. My emphasis. Section 39, subsection 1B of the Constitution, which requires a court when interpreting our Bill of Rights provisions to consider international law. The term used is must. In terms of section 39(1)(c), also indicate that reference may be had to foreign law but not prescriptive. It provides that only the court may consider it when interpreting those provisions. South African courts actively consider international law when interpreting the rights to a fair trial in terms of section 35 of the Constitution, ensuring that the domestic legal procedures align with international rights standards. The English common law in relation to the admissibility of extraocular statements is useful summarized in the following passage of Lord Elsham of St. Marysbone, Hillsborough, Law of Evidence, 4th edition, 1990, volume 11, 2 in brackets at paragraph 1131. And I quote, confessions by one or two or more accused, where several persons are accused of an offense, and one of them makes a confession or an admission, that confession or admission is evidence only against the party making it. Where the statement is admissible, the information in it may be used to extract from the accused in the form of evidence made on oath all that he has formally said about a co-accused. Statements like acts done by one of several accomplices or conspirators in pursuance of a common design are evidence against the others, but statements which not made in pursuance of a common design are evidence against the makers. Close quotation. The bank records. In terms of section 236 of the Act, the state produced proof of entries in accounting records and documentation of bank records, Exhibit EE, subsection 3 in brackets of accused 4. The relevant pages of bank records are pages 21 to 25 and cover the period from the 28th of August 2014 to 30 April 2014. The state indicated that the relevant pages of the bank records were page 24, the entries of 25 October 2014 to 27 October 2014, which depicts the following on page 24. There is nothing in the bank records, my lord, that suggests that accused 4 received any proceeds from the mastermind for the killing of the deceased. In fact, the record supports the accused version, and there is nothing that turned out of them in the state presentation of the bank records that implicates accused number 4. As they show the inflow and outflow of funds, which are immaterial in the present case. My lord, I'm informed that it is 1,300 hours.
Is that so?
Yes. May the court adjourn for lunch.
Until 2 o'clock.